Hey everyone, the unit we'll be doing today is public law, and my name is Shazia Khan. We'll be doing learning outcome 2, which is to understand the meaning and consequences of separation of powers. Firstly, what we're going to do is have a look at a summary of what we did in the last session, which was learning outcome 1. We looked at the foundations of constitutional and administrative law within the UK. And we identified the significance of sovereignty of Parliament and why Parliament's so important. We looked at what the UK Constitution is and what the does the UK have a written or unwritten constitution, and looked at the issues in regards to different countries having a single document. We looked at the history of the UK Constitution, such as Magna Carta, Bill of Rights. We looked at the role of Parliament within the UK and the Constitution. We identified, excuse me, the British Constitution, how it evolved over a period of time, reflecting on statutes, conventions, judicial decisions and treaties, etc. So we looked at the sources of the UK Constitution as well. We also looked at the UK's complex constitution with the European Communities Act 1972, and also looked at statutes law that were passed by Parliament. We also looked at an uncodified constitution and how it creates problems. We looked at the two houses, which was the House of Commons and House of Lords, and what they actually did. We looked at the characteristics of the UK constitutional system, such as works of authority, EU treaties, conventions, etc. We looked at the principles of the UK Constitution, such as parliamentary sovereignty, rule of law, the monarchy, the EU membership. We looked at the sources of the UK Constitution, again mentioning the statute law, common law, royal prerogative, major works of authority, conventions, EU law and parliamentary sovereignty, and the rule of law. We looked at the timeline of major events in the UK Constitution, when the Magna Carta was signed by the King John in 1215 up to 1998, when the Human Rights Act was implemented. We also looked at the strengths and weaknesses of the UK Constitution with reference to parliamentary sovereignty, the rule of law, parliamentary government, constitutional monarchy, and the EU membership. We looked at the significance of constitutional conventions within the UK and why they're important and why they're actually used by courts in the UK, and the purposes of constitutional conventions within the UK and how they play a key role within the UK. We looked at academics and legal authorities' work, such as DiL, and what he implemented within the UK economy in regards to what his ideology was in regards to constitutional conventions. We again looked at examples with regards to that, using the example of Tony Blair and the issue of weapons of mass destruction in regards to Iraq. We also went on to look at different academics and what they thought of the UK Constitution in regards to conventions. We looked at checks and balances and parliamentary sovereignty. We looked at the different types of sources, again, of the UK Constitution, and the issue around judge-made law, which was common law. And we went on to identify whether the UK needs to have a written constitution or not. Now we're going to look at understanding the meaning and consequences of separation of powers. Key terminology. So you've got what is the legislature, and the legislature makes laws. What is the executive? The executive puts those laws into effect and plans policies. What is the judiciary? The judiciary administers justice by interpreting the law, when its meaning is in dispute, ensuring the law is upheld. So there are three arms of government and their functions: the executive, the judiciary, and the legislature. Before we go on to that, it's a short video in regards to separation of powers and what it is, okay? Share that with you now.
Every man for himself, no police, no laws, no judges, and in the end the strongest wins. But wait just a minute, what if the state enters the picture? If it's the only one to use violence, then it will ensure peace and security. That, at least, is what the philosopher Thomas Hobbes said in his book Leviathan back in the 17th century. Hobbes' Leviathan symbolised the power of the state. But this Leviathan has often abused its power. Rulers have oppressed their own people and used violence for personal gain. They've controlled administrations and police and imprisoned those who stood in their way. Oh, no. Government in the hands of the powerful, a combination that over the centuries has often led to oppression and death. The solution? Distribute the state's power. Lawmaking, governance, administration, the justice system. Every branch should operate independently and remain separate. That's the way it is in Germany, in the United States, and in most other countries on earth. But authority isn't just distributed at the highest levels. Regions, cities and municipalities can also hold part of the power. With regular democratic elections and limited terms of office, it's nearly impossible for any one person to monopolise power. After all, authority has been well distributed. If some still persist in attacking their neighbours, then they are tried by independent judges according to the law. Everyone else is protected from violence.
As we can see from that video, it's just a short understanding of what separation of powers is and the issue of abuse of power. If separation of powers does not work in the state, how it is abused and how people have abused it previously. So we'll carry on with the slides now. So what does it mean to have judicial? So it's an adjective pertaining to the judgment in courts of justice or to the administration of justice. Judicial proceedings, the judicial system pertaining to courts of law or to judges. Judiciary, judicial functions, decreed, sanctioned or enforced by a court, a judicial decision. What is judicial appointment? It's an appointment of a member of people or a candidate to judicial office in courts and tribunals is called a judicial appointment. The Judicial Appointments Commission, JAC, is an independent commission that selects candidates for judicial office in courts and tribunals in England and Wales, and for some tribunals whose jurisdiction extends to Scotland or Northern Ireland. What is separation of powers? As we saw in the video, separation of powers is an important concept for the UK Constitution, as it separates the powers against the judiciary, the legislative and the executive, so there's no abuse of power. So separation of powers is a doctrine of constitutional law under which the three branches of government, as I mentioned earlier, executive, legislative and judicial, are kept separate. This is also known as a system of checks and balances. because each branch is given certain powers so as to check and balance the other's branches. The separation of powers is a constitutional principle introduced to ensure that the three major institutions of the state, namely the legislative, the executive, and the judiciary, are not concentrated in any single body, whether in functions, personnel, or powers. Legislative is a lawmaking body, executive puts into the law into operation, and judiciary interprets law and settles disputes. 2.1. Explain the distinct roles of the legislature, the executive, and the judiciary. So the overview of the UK government, the UK Parliament model of parliamentary government is the executive is the Prime Minister and Cabinet, who's accountable to the judiciary, and also accountable the personnel, House of Commons, Legislative, and House of Lords accountability, and then the electoral legitimacy and accountancy. Role of legislature. The legislature branch is Parliament is the British legislative body. It is made up of two houses, so we have the House of Lords and the House of Commons. It performs four primary duties: passing laws, authorising taxes and government budgets, scrutinising and investigating government administration, and debating current issues. The UK legislation may take the form of acts passed directly by Parliament or statutory instruments made under the authority of an Act Parliament by either government minister or by the Queen in Council. And today it is the King. The latter are generally subject to parliamentary approval, which is affirmative procedure, or parliamentary disallowance, which is negative procedure. The majority of acts considered in the UK are defined as public general acts or acts of Parliament, as they have progressed and gained approval as a bill through the House of Commons and the House of Lords, and also have gained royal assent from the monarch. The local and personal acts of Parliament are also presented to Parliament as a result of sponsored petitions. These, however, are processed through committees to enable relevant or affected parties to challenge or change the proposed acts. Prerogative instruments made by the sovereign under the royal prerogative are another source of UK-wide legislation. The UK Parliament is responsible for all matters relating to defence and all foreign affairs and relations with international organisations, particularly the United Nations, the Commonwealth, and the European Union. The two houses of Parliament legislature. So we have the House of Commons and we have House of Lords. So the House of Commons is the lower house of Parliament of the United Kingdom and is elected chamber consisting of currently 650 members, known as members of Parliament, and which are elected using first past the post in a single member constituency with 533 elected from England, 59 from Scotland, 40 from Wales, and 18 from Northern Ireland. The House of Commons is now considered to be the supreme chamber of Parliament. We have the House of Lords, and the House of Lords is the upper house of the Parliament of the United Kingdom. However, it is unelected chamber, with all members to the House of Lords being appointed. As of August 2018, there are currently 793 members, known as peers. The House of Lords no longer has the same power as the House of Commons under the Parliament Act 1911 and 1949, especially when it comes to blocking general legislation and passing of financial legislation. So now we're going to look at the different stages in English lawmaking and what the stages are for laws to be passed. So the stages in lawmaking. So the stages involved in lawmaking in the English legal system includes a bill, which can be introduced by the government or an MP. Initial proposals are set out in the Green Paper for discussion, which is after feedback. A White Paper is presented to the House. So this is the introduction. Then we have the first reading, is the brief and just an introduction. The document is printed and circulated to all members, and that is the first reading. Then we have the second reading. This is reading is the most important, as it's the first opportunity to debate the contents. There's a vote at the end and the bill can be voted out and defeated at this stage. So this is the second stage. This is the detailed on the bill and is, as we mentioned, debated and amended. MPs then vote whether the bill should proceed or not. And then the whip system is mainly used at this stage to get members to support their political party, which may always cause the majority, is the current government, to win. Then we've got the committee stage, and it involves detailed examination of the bill, followed by proposed amendments, and each clause is agreed, modified or removed. Then we have, once this committee stage has finished its scrutiny of the bill, it reports back to the House for another debate of the bill, and any amendments need to be made. And here at the report stage, the bill is further debated and voted upon by the House. And then we have the third reading, and this is the final chance to debate the bill and is restricted to all its actual contents rather than what should have been included. There is a final vote on the bill. So in this one, the bill is represented to the House. Short debate may be done and then vote whether it should be accepted or rejected. So then when we look at this, this is the House of Commons or Lords, and then the first reading, second reading, committee stage, report stage, and then the third reading also at the House of Commons or Lords if the bill is voted in. Then then it receives royal assent. Once both houses have approved the bill, the Prime Minister presents it to the monarch, and once she has signed it, and at the moment it's the King, the bill becomes an Act of Parliament. And this is the final stage. This formality is done under the Royal Assent Act 1961. The monarch will not even have the text of the bill she's assenting to. In 1707, the monarch, Queen Anne, refused to assent to the Scottish Militia Bill. So the source used in regards to this is Hart et al. 2012, where this diagram was taken from. So the role of the executive. The executive comprises of all official and public authorities, including local authorities that govern the UK, from initiating and implementing legislation to the running of local and national services, such as rubbish collections and the police. The executive is a branch of government exercising authority in and holding responsibility for the governance of the state. The executive executes and enforces law. The Prime Minister and the Cabinet, the Prime Minister being the de facto leader of the UK, he or she exercises executive functions that are nominally vested in the sovereign by way of royal prerogatives. Historically, the British monarch was the sole source of executive powers in the government. The executive branch can be the source of certain types of law because they are able to make executive decrees or executive orders, and executive bureaucracies can be by the source of regulations. So the executive branch of government consists of leaders of offices with top leadership roles, including the head of state, which is the Queen in the UK, a ceremonial position, which at the moment is the King, the head of government, the Prime Minister in the UK, and the de facto leader, in addition to a Defence Minister, an Interior Minister, the Home Secretary in the UK, a Foreign Minister, a Finance Minister, the Chancellor of Exchequer in the UK, and a Justice Minister. The role of the Judiciary. The responsibility of the judiciary is to protect citizens against unlawful acts of government has thus increased, and with it, the need for judiciary to be independent of government. The judicial power, the main function of this branch is to hear upon and resolve the matters of the law. However, in the UK, the judiciary has one more essential function, which is to develop the law through their judgments. The judiciary consists of judges in courts as well as those who hold judicial office in tribunals. The role of the court system is to decide whether, including a determination of the relevant facts, then the determination of the relevant law and the application of the relevant facts to the relevant law. The courts must ascertain what the relevant facts are, and this may require a court to resolve a dispute about the facts. Secondly, the court must determine the relevant legal rules to apply in particular case. In certain instances, the court may even be required to clarify, develop, or supplement existing legal principles in order to apply the law to new factual situations. Finally, the courts must apply the law to the facts. It must determine that the facts satisfy the relevant legal requirements of the criminal offence or civil liberty. Montesquieu's rationale for maintaining the distinction between legislature, executive powers, and judiciary. Montesquieu was a French writer, philosopher, and he believed that if all three powers were held by the same person, there would be a dictatorship and arbitrary rule would prevail. Another writer, John Locke, mentioned that the three organs of the state must not get into one hand, as it may be too great a temptation to human fatality. Aristotle is of the opinion that if the three organs of the state is well arranged, then the constitution is bound to be well arranged. The term separation of powers can be defined in the strict sense and the liberal sense. In the strict sense, separation of powers means that there should be a clear distinction of functions between three organs of the state, and there should also be a check and balance between the three organs. There should not be any overlaps in functions, personnel, and powers. In the liberal sense, separation of power means that there could be overlaps in functions and personnel between the three organs, but there should also be checks and balances between the three organs. 2.2. Evaluate reforms to the judicial appointment. Judicial appointment and the rule of law. Judiciary and the rule of law. And there's further reading that you could do on www.legislation.gov.uk in regards to the judiciary and the rule of law. Judicial independence, when we look at judiciary and the rule of law, is a prerequisite to the rule of law and a fundamental guarantee of a fair trial. A judge shall therefore uphold and exemplify judicial independence in both its individuals and institutional aspects. Impartiality is essential to the proper discharge of judicial office. The Constitutional Reform Act 2005. The Lord Chancellor's role changed dramatically on 3rd of April 2006 as a result of the Constitutional Reform Act 2005. For the first time in almost 900 years, judicial independence is now officially enshrined in law. The key changes brought in by the Act include, firstly, a duty on government ministers to uphold the independence of the judiciary, barring them from trying to influence judicial decisions through any special access to judges. Secondly, the reform of the post of Lord Chancellor, transferring their judicial functions to the President of the Courts of England and Wales, a new title given to the Lord Chief Justice. The Lord Chief Justice is now responsible for the training, guidance and deployment of judges and represents the views of Judiciary of England and Wales to Parliament and ministers. Thirdly, an independent Supreme Court has been established, separate from the House of Lords, with its own independent appointments, system, staff, budget and building. Fourthly, an independent Judicial Appointments Commission responsible for selecting candidates to recommend for judicial appointment to the Secretary of State for Justice. The Judicial Appointments Commission ensures that merit remains the sole criterion for appointment, and this appointments system is modern, open and transparent. And fifthly, a Judicial Appointments and Conduct Ombudsman responsible for investigating and making recommendations concerning complaints about the judicial appointments process and the handling of judicial conduct complaints within the scope of the Constitutional Reform Act. The real differences are in the day-to-day management of the judiciary, the way judges are appointed and the way complaints are dealt with. These are now truly independent to enhance the accountability, public confidence and the effectiveness. So the Constitutional Reform Act 2005 actually brought in a lot of changes to try to make the judicial system more effective and more independent, so that people were able to rely on it more. 2.3, assess the significance of separation of powers principle. The separation of powers is a constitutional principle introduced to ensure that three major institutions of the state, namely the legislative, the executive and the judiciary, are not concentrated in any single body, whether in functions, personnel or powers. The term separation of powers can be defined in the strict sense and the liberal sense. In the strict sense, separation of powers means that there should be a clear distinction of functions between the three organs of the state, and should also be a checks and balances. There should not be an overlap in functions, personnel and powers. In the liberal sense, separation of powers means that there should be overlaps in functions and personnel between the three organs, but there should also be checks and balances between the three organs. The UK has a separation of powers. There are clear overlaps both in terms of personnel and function between the three organs of the state, which may be discerned. The government powers should be exercised by legislative, executive and judicial within their own limitations, and it should also check each other out as checks and balances. So we've got in the diagram the judiciary, which is there to power to make judgments on law. Then we've got the executive, which is the government, and they've got power to put law into action. Then we've got Parliament, the power to make and change the law, and that would be through delegated legislations. The executive and the legislature. In the UK, the government personnel is provided by Parliament. The Prime Minister and the Ministers of the Crown must be members of either House of Parliament. The powers of government are scrutinised by Parliament. However, there are some limitation to that under the House of Commons Disqualification Act 1975, which allows certain people to hold a parliamentary office, and there's also limitation to the number of government ministers to the House of Commons. Despite that, the government will still have automatic support of 120 members of Parliament. The operating period for the government depends on Parliament. We can also see the interference of executive in Parliament through delegated legislation, as the legislative function is exercised by the executive and not the Parliament. A vote of no confidence against any government policy can result in the downfall of government. The opposition will oppose or support the government based on how they govern the country. Question time and debates and select committees are part of checks and balances, which help to ensure the accountability of government to Parliament in any matters. Election is a way which citizens can use to object or agree with the government by voting. The legislature and judiciary. In the UK, Parliament is not allowed to discuss certain issues if it has yet to be brought to the court back for trial. Parliament also cannot criticise judges. However, since UK adopts parliamentary supremacy, Parliament has the power to influence the judiciary. Parliament can dismiss any court decision through legislation, and judiciary is supposed to interpret the legislation passed by the legislature. Judges also said to play the function of legislator by applying the doctrine of precedent and by interpreting statutes through statutory interpretation. Basically, judges gives meaning to statutes passed by legislature, and the meaning given might not be what was intended in the first place. Therefore, judges are also said to make law, and in cases where there is no law for certain areas with such cases before them, judges have to come up with a reasonable new principle. The judiciary includes all judges in the courts of law, including those who have judicial offices in tribunals, and lay magistrates who staff the magistrates' court. This is preside in the civil and criminal courts by professional judges. Civil jurisdiction covers both private law issues and also public law questions. The courts exercise certain minor legislative functions, such as making rules, governing court procedures, and also administrative functions. Executive and the judiciary. In the UK, the prerogative is part of common law. Judges actually define the existence and scope of the prerogative, apart from the law officers of the Crown, such as the Attorney General and Solicitor General, are members of the government. The law officers' duty is to advise the government and ministers. Judicial review is a way that can be exercised by the courts to ensure executive do not abuse their powers and as means to uphold the rule of law. Judicial review by the courts is a way of checking on executive, is also said to be kind of an overlap between judiciary and the executive. The interference of executive in judiciary can be seen in the powers of executive to appoint judges. (2D1) Evaluate the extent of UK Constitution's adherence to the separation of powers principle. There is no absolute doctrine of separation of powers in the UK's Constitution. Britain's concept of separation of powers, that Parliament, executive and courts have their own parameters and should exercise their powers accordingly. The UK has a separation of powers. There are clear overlaps both in terms of personnel and function between the three organs of the state, which may be discerned as mentioned earlier. The government powers should be exercised by legislative, executive and judicial with their own limitations and should also check each other. Britain's concept of separation of powers, that Parliament, executive and courts each have their own parameters and each should exercise their own powers accordingly. The monarchy used to influence over government, but now it's like a symbolic for government, however, is sovereign. John Locke and Charles Montesquieu are the significant figures as mentioned earlier for this doctrine. According to Montesquieu's vision, the separation of powers is an idea where checks and balances works like you're running after someone in a circle and they're running after you. One person should not perform his duties in three organs of the government at a time. Each organ of the government should not interfere with other organs. For example, ministers should not have legislative powers. The executive consists of government, including the Prime Minister and the Cabinet, other than in the legislative functions of Parliament. The role of the executive is to implement government policies. These include implementing legislation, security, providing social and economic welfare, administrating public services, and also try to make good relations with other countries. Therefore, the executive function techniques ranging from the formation of broad policies to the detailed management of daily routine services. In the UK, new law is enacted when the bill has been approved by the House of Commons and House of Lords, as we mentioned, through looking at the procedure earlier, and received royal assent. However, under the Parliaments Act of 1911, and 1949, legislation may be enacted even though it has been rejected by the House of Lords. House of Lords can only delay it for up to 12 months. The interpretation of statutes is a vital part of lawmaking process, because after such interpretation that is known whether the intentions of those who frame the law have been carried into effect. During this procedure, the judges must not challenge the political authority of the legislature to decide what net laws should be made. The judiciary include all judges in the courts of law, including those who have judicial offices in tribunals and lay magistrates who staff the magistrates' court. This is to provide in civil and criminal courts by professional judges. Civil jurisdiction covers both private law issues and also public law questions. The court's certain minor legislative functions, such as making laws, governing court procedures, and also administrative functions, as mentioned earlier. Separation of powers is divided into 3 organs of the state, and these organs must communicate with each other to run the country effectively. Even if the constitution is written, still certain requirements has to be followed to govern the country smoothly, because if these 3 organs are conflicting with each other, and it can be destruction for the country and its people. At the end of the day, all the things, separation of powers, organs of state and monarch, are for the welfare of the rights of people of that country. Cabinet direct the activities of central government departments through their majority of House of Commons, exert controlling influence over its timetable, business and legislative output. The government legislates in the form of regulations controlled in statutory instruments. Before the Constitutional Reform Act 2005, the head of the Judiciary of England and Wales, a member of Cabinet and the Speaker of the House of Commons, was Lord Chancellor. He was part of 3 organs of the state, and this was exception to the doctrine of separation of powers. Visible overlaps are found in legislative, judiciary, and executive. However, the systems of checks and balances are there. This involves each branch having eye on the other, but also required each organ to be protected against interference by others out of their parameters. The Prime Minister can advise the Queen to dissolve the Parliament, but it must meet within a year. The Queen in emergency can dissolve or refuse to dissolve Parliament. Individual ministers are accountable before Parliament. House of Lords is a partial check over the executive. Judicial appointments are made either by the Queen, which is the King now, on the recommendation of Lord Chancellor, or in the case of lay magistrates and certain other junior judges, by the Lord Chancellor directly. The senior element must be chosen by the Judges' Council. The lay members must be selected by a panel of 4 persons. These comprise a lay chair, the Lord Chief Justice, and the chair of commission. Civil servants are not members of the commission. The Lord Chancellor can increase the number of members subject to the approval of Parliament. Commissioners cannot hold their office for more than 10 years in total. In exceptional cases, Lord Chancellor can remove judges on medical ground. Superior court judges must retire at 70, and courts cannot abolish act. However, courts can check whether a document is genuine and act. The Human Rights Act 1998 provides a clear balance between the 3 branches by requiring the courts to scrutinise acts of all the branches in light of main provision of the European Convention of Human Rights. However, Parliament can override the Convention rights by using very clear language. House of Lords held that the courts can look in Hansard where the language of an act is ambiguous. So after the 1968 settlement, the House of Lords was regarded as holding the constitutional balance of power. Life peers were introduced in 1960s, but their constitutional role remained controversial. By convention and the law, the Lords defer to Commons. Although Commons exercise a control by executive, yet the House of Lords is accountable to no one. All the above are the checks and balances to prevent against abuse of powers in the UK. Hence, we say in trying to accomplish a state in which separation of powers exists, is imperative to accomplish a system of checks and balances. Now we see that what the current administration has sought to strengthen these checks and balances. The theme of modernisation has been integral to the New Labour project ever since Tony Blair became leader of the party in 1994. At Labour Party conference 1994, Tony Blair said that the government has a mission to modernise the biggest programme of change to democracy ever proposed. William Hague, opposition leader, argued in a full-scale debate on Parliament and executive, said that Labour government has rapidly accelerated the process of decline in Parliament in relation with executive. Now we talk about Gordon Brown and most recent modifications. Constitutional Reforms Act 2005 provides latest reforms to strengthen these checks and balances, also to stop misuse of power, abuse of power. It also helps determine better powers of separation of powers in the UK. It is an act to make provision for modifying the office of Lord Chancellor and to make provision relating to the functions of that office. As a result, Lord Chancellor's role changed dramatically, and now he can be from either House of Commons or Lords. And judicial independence is now enshrined for the first time. The other key reforms are duties on ministers to uphold the independence of Judiciary, including introduction of Lord Chief Justice, introduction of new independent Supreme Court with its own separate appointment system, budget and own building, as well as it abolishes the appellate jurisdiction of the House of Lords. From late 2009 onwards, the Appellate Committee of the House of Lords will be transferred to the Supreme Court, consisted of 12 justices of the Supreme Court. When the court is first established, there will be the same 12 judges comprising of the above Appellate Committee, which is the Law Lords. Until such transfer of functions and personnel has been effected, judges of the Supreme Court will not be able to sit or vote in the House of Lords, and also membership from the House of Commons. The monarch will make appointments to the Supreme Court advised by the Prime Minister. The selection process will take place prior to submitting nomination for royal approval. The selection process will be taken by an ad hoc selection commission of 5 members. Lord Chief Justice and the senior judicial figures will be included in the commission. Commission proposals will then be transmitted to the Lord Chancellor, who may at that stage mention the name of the Prime Minister, decline the name if they consider the person unsuitable, and require further thought by the Commission. The Constitutional Reform Act 2005 was the reason why the practical and legal operation of the doctrine of separation of powers was given clarity and effect. The primary purpose of the Act was to achieve a more distinct separation of functions and personnel between the legislature in the form of House of Lords and Judiciary. This has been done by providing the creation of the Supreme Court in the UK to replace the Appellate Authority Committee of the House of Lords, and by removing the Lord Chancellor from the judicial process. When we look at the issue of separation of powers today in the UK, it's very hard to identify that, there is no abuse of power. But when the institutions work together, it argues that it works better, and the powers are neither, there's neither abuse of power. in the book of Bradley and Yu in 2006, he argued that a strict separation of powers is neither possible in theory nor practice. Then Barnett, 2006, believes that strict separation of powers to be unworkable, leading to constitutional and legal deadlock. Baygot, 1867, considered that the UK to have a partially fused separation of powers, describing it as the efficient secret of the UK, preventing political deadlock. Either way you view the theory of separation of powers, Young's 2019 stated that they are fundamentals, as is, I believe, true. So there are different views of academics in regards to the UK having the separation of powers and how there would be an abuse of powers. But this issue of checks and balance tries to prevent a kind of Hitler-style system. So, you know, there's not abuse of power. So we've finished the session now. Thank you for your patience and thank you for attending the session. The references we've used for this session are listed there. So we've got Wikipedia, Wiki Legislatures of the UK, tutor2u.net, parliament.uk, About Living, Heritage, Evolution of Parliament, House of Lords, Judicial Role, Law Teacher on the Judiciary, the judiciary.uk, about the government and the constitutional reform, internship, importance of separation of powers in the UK, and we've looked at the Law Teacher, constitutional reform and the principle of separation of powers, and some links there that you can go on to help you with the assignment bit. Also, there will be additional resources available for you on Moodle to do some reading around the area. And the next session we will have is Learning Outcome 3. And thank you for your patience and thank you for attending today's session. Thank you.